Okay, so this is part 3. Still the defense questioning the cop.
By anybody in particular to get involved?
I do not know that personally. No.
Have you heard?
I have my understanding that the governor has made a statement to that effect in the news media that he directed the director, but that was relayed to me secondhand. I did not see that directly.
Did you get any information about what the governor directed Mr. Reynolds to do?
No, sir.
Okay. In your getting into the case, did you consult with any attorneys as you were moving into the case around May 5th and May 6th?
We not at May 5th or May 6th, no, sir.
Okay, this is a stall. This is where the defense asks a bad question. Instead of giving dates to allow him wiggle room to remember or not, he should have just left it open-ended. Did you confer with any attorneys? And who were they? Who's every attorney you talked to? That would have been a better question to get his information. Instead, he put 5th and 6th, and now this cop, well, not on the 5th or 6th. Listen to that carefully.
Did you consult with any attorneys?
Should have stopped right there and said, can you give me a name of all those attorneys?
You were moving into the case around May 5th and May 6th.
We not at May 5th or May 6th, no, sir. On May 7th, we had a meeting with Tom Durden, which was the district attorney assigned to the case, where we laid out and discussed the legal aspects of the case with him.
And was he your point of contact in terms of...
Notice how this whole questioning about all attorneys just got deflected to one attorney. Now he's got the defense locked on this one attorney, and he never really answered all the other attorneys that he consulted with. That's a critical piece. Hopefully the other defense attorneys pick that up and will clear that up, and they're writing that down. Discussing
what warrants you might take?
Yes, sir. At that time, yes, sir.
Okay. This was prior to the DA from Cobb County being involved, Ms. Holmes?
That's correct, yes, sir.
And so as you are stepping into the case, you said that you received information that you were going to get involved around May 5th. Is that correct?
I got a call on the evening of May 5th by my SAC advising that the GBI had been requested in reference to the case.
SAC, Special Agent in Charge?
Yes, sir. Okay. Yes, I'm sorry. Yes, Special Agent in Charge. I then received a call from my inspector.
Cops do that a lot. We use acronyms on the stand. Most people don't know that. Good attorneys will clear it up like he did, or will ask you, what does that stand for? Because if this goes to appeal, when other judges have to review this, they only review the transcripts. So when you let things like this go, when cops get up there and testify, he told me, and we did this, and they did that. It drives me nuts when I hear cops using we and they. We and they don't do shit. Who did what? What did you do? And what did the other person do that you're calling they? Okay, so when he just goes, well, I got a call from my CBA or my CBI or my ABI or FBI or my AIA, whatever. Don't use acronyms. That's a cop tip.
On the morning of the 6th, instructing me that I was the assigned case agent.
Did you learn anything about the case from either of them?
No, sir.
For what the directive may be?
Just to investigate the case was my understanding.
Were you aware of the shooting that had happened back on February 23rd prior to the 5th?
Yes, sir, I was.
Were you aware of what was happening with demonstrations and what was happening with unrest in the community?
Yes, sir, I was.
So he just said, I kind of got asked to do about the case and I don't know much about it, yet he had been seeing the outrage and the video and that 2 attorneys were refusing to prosecute. But right before this, he was kind of like, yeah, I just got the call about the case.
Had you at any time ever spoken with Glenn County Police Department, anyone in Glenn County, about their investigation prior to your involvement?
We had a discussion with them about the expected protests, but...
When was that conversation?
We had a conversation. Who the hell's we? You and who else? Who was in the room? The defense attorneys are missing this and letting this cop use these terms, and these are terms that cops kind of cover their butts on without saying who the hell we is.
I know there was, I believe earlier that week, that Monday, I believe there was.
Who thinks he looked at something in that file that helped him? That's what we call a stall or delay. Watch how quick he looks at this file. This file doesn't make him recollect anything. He's kind of nervous and he's buying time. A good person on the jury will pick this up.
I believe earlier that week, that Monday, I believe, there
He didn't read that. You think he saw something in there that said earlier in the week to answer this question? Of course not.
was that or the week before.
In May?
Yes, sir. Yes, sir. There was information about a protest, and the Glenn County Police Department interim chief of police, Jay Wiggins, contacted all local and state law enforcement in the area to have a meeting in reference to possible resources they could provide in reference to any protests that could occur.
What was your belief about the work that Glenn County had done in their investigation, and whether that investigation was a good and thorough investigation, and whether they had made the right decision or the wrong decision?
Objection is to relevance. It doesn't really matter.
He doesn't want to answer that, but that's a good question, because a few seconds ago, this cop testified that when he got the call, it was kind of out of the blue and didn't really know much about the case, or I forgot his words. But the implication was, no, this was just a regular call. There was no big deal. When in fact, this was a big deal. There was going to be riots. And if the DA that was there was refusing to prosecute, this guy knew it. He's an investigator. And he's just like anybody else. Hell, I knew it. And I'm not even working in the area. And I knew that this was a big deal. But this cop, who's in his city or his state, and he's going to be the investigator, acted like, no, I was just going to call for the case. And, I was just, whatever. Come on.
What other investigators might think about the case. This is probable cause.
You can ask them, what did they do?
Okay, how will you know? What were you aware of what Glenn County had done in their investigation prior to that early week in May when you were asked to get involved?
All I knew is they had conducted an investigation. I didn't know.
Were you aware that they had made the decision not to make an arrest?
Again, object to relevance.
I rephrase.
He doesn't want him to answer, because if he knew that they didn't have arrests and he was asked to go in, everybody knows in the system that, look, this is a political case and they're coming in to take over this case because the state thinks you screwed up. The state doesn't want riots. The state wants the outcome that they want, and they're coming in. All cops know this. All investigators know this. And he's acting like, oh, well, I'm kind of... And the prosecution doesn't want him to have to say that. If I was up on the stand and asked that, I'd be like, yeah, it was a big deal and there was riots. And we knew it was politically involved, and it was... People were trying to make it into a racial issue, and they wanted outside agencies to get it. And that's why I think we got involved. That's what I think, if you want my opinion. Objection, Your Honor! He's stating facts, not evidence. The officer isn't here to give his opinion. He's here to testify. And then the DA gets you afterwards like, dude, why are you trying to screw my case? Why? I go, I ain't trying to screw your case. I'm telling the freaking truth. If that screws your case, sorry, that's the way the cookie crumbles. Rick, you need to be more of a team player. Shut up. I don't want to hear that bullshit.
Were you aware of the letter that the DA had written to the sheriff, George Barnhill had written?
Look at this pondering thought. Lips tight, looking up, head tilted back. Man, I really got to think if I'm... Are you kidding me? I knew that letter existed as soon as they didn't file, and the news media plastered it everywhere. Anybody that wasn't locked in a freaking cave knew about it.
About his decision not to arrest.
Objection, relevance.
I don't want him to say he knew that. Why would you object to something? I mean, it's the truth. Why would you care? Because the DA doesn't want the truth. The DA wants to win his case. The DA wants to push his political agenda. That's what it's about.
See what that has anything to do with the case. Ask another question.
Okay. May I ask if he's aware of the letter, Judge? The letter has information in it about the Glenn County investigation. I'd just like to know if he reviewed it.
You can ask him about the letter.
Have you read the letter by Mr. George Barnhill, the district attorney, to the sheriff at Glenn County?
Not to the... Yes, sir. I read the letter that he wrote in reference to Tom Jump, I believe, which is not the chief of police, but I think he was captain of investigations.
Okay. And you've read that letter?
I have, yes, sir.
So prior to engaging in your investigation, you had an understanding of the decision not to make the arrest.
Object to relevance.
I'll let you ask the question.
Again, all these objections, when the jury's there, attorneys don't like to object like this, because the jury's like, why don't you let him answer the question? I want to know the information. What are you trying to hide? Why are you making it so difficult for us to hear the truth? If the guy's lying, then don't put him on a stand or tell us he's lying. But you're trying to stop him from saying something that isn't necessarily a lie. You just don't want us to hear it. Jurors will pick that up if they pay attention. of course, when you pick a juror, you're only picking jurors that are too stupid to get out of jury duty, so you want a bunch of idiots.
Not prior to my investigation. I believe I read that letter during my investigation.
Okay. And when you got involved in the morning of May 6th?
I believe I read the letter on May 6th, yes, sir. Not in the morning. I believe it was in the afternoon.
I believe. Now, I used to do that a lot, and some people will say that's kind of like, I just like it because it gave me wiggle room. I didn't want to lock myself down unless I was absolutely sure. If you asked me what I had for lunch, I'd say I had, you know, a donut with sprinkles. But if you asked me what I had for lunch 4 weeks ago, I might go, I believe it was a donut with sprinkles. But if you got video that shows me eating a chocolate-covered donut, well, then I would be wrong. But I believe it was a donut with sprinkles. So that's why when cops use the words, I believe, I think, to the best of my recollection, all attorneys will tell you to use that when you give statements that you aren't 100% absolutely sure. Now, it sounds like you're sure to the normal listener and to a jury, because they'll be like, oh, he must be telling the truth because he answered it pretty quickly and he said he believes, and we have no reason to believe he's lying. Well, no. If he's saying I believe, you have to lean on, that's not fact. He doesn't know for sure. He's kind of guessing. He's kind of maybe. He's if, and, but, and coconut nuts, but he's not for sure.
I read it.
The decision to take the warrant, what time did you decide, and what day did you decide that you were going to be taking a warrant for the arrest of Travis McMichael?
That would be the afternoon of May 7th when we met with the District Attorney Tom Durden and discussed the facts that we had accumulated and asked his legal opinion concerning various matters.
Okay, so when you get involved in the morning of May 6th, by the afternoon of May 7th, you said you have reviewed facts.
Yes,
correct? Okay.
and conducted investigative acts.
And conducted investigative acts.
Yes.
What did those investigative acts include?
Well, we had an agent. I cannot recall every investigative act that was conducted during that time frame.
Well, if you had brought the case file like he asked, maybe you could have refreshed your recollection and went through the case file. But I don't want to do that, Rick. I want to be able to say, I'm not sure because I don't want the information out.
I understand that.
Mm-hmm.
And if you need to refer to your case file that you brought with you, we can give you the time to do that.
But they would necessarily.
This was a slight. This was a dig. This was a little stab in the back by the defense. Most people don't catch that. But when you get a dude that's trying to bullshit you, you give him rope and lead him right down where you want him to go. This defense attorney just pulled a slick one, and he'll sucker you once or twice if you're a seasoned investigator, but he won't get you again. He's giving this guy room to say, look, no problem. I get it. You don't understand. You're an honest officer. Just go ahead and refer to your case notes and give me the answer. And now the guy's got to say, well, I can, and I don't have all my case notes, and I didn't. Oh, so you made a thing to file, but you don't really even know why you filed. He's making a perfect example of this guy kind of bullshitting him.
My case file is not complete, so I wouldn't know if those acts had been documented or not. So that would not help me to properly.
Anytime you can get a cop saying, I don't know, or this ain't complete, or I'm not sure right now, those are all wins for defense attorneys. Because the more you get the cop to say that, the cop is the prosecution, the more it makes the prosecution case look weak, the more jurors are like, man, they kind of did a shitty job. They can't even remember who the hell they hiring here. Freaking, Mr. Magoo, he can't read a report? What is this?
Reflect all the investigative acts that occurred.
What I want you to focus on, if you don't mind, is you made a decision to take warrants for felony murder and aggravated assault against Travis McMichael.
I did, yes.
Afternoon of May 7th. So
yes.
Within a little greater than a 24-hour period.
Yes.
So I'm asking you then, what investigative acts did you do within that 32-hour period to make the decision?
That's a great point, and the defense attorney's doing a good job. You had a case to where you knew that 2 DAs and the cops did not arrest this guy because they said they didn't have a case. Suddenly, you get a call from your boss because the governor tells him to get involved, and he calls you, and you act like, yeah, this is just a normal case. I just got called in. I didn't know a whole bunch of facts. Suddenly, 24 hours later after you get the case, you determine to make an arrest. What was the revelation? Another question the defense, I think, missed is that, in your opinion, you're an experienced investigator. In your opinion, if an entire office of cops and investigators choose not to file, and a DA chooses not to file a case, In your opinion, do you think that's a good case, or do you think they did that for the wrong reason, or do you think with their experience they made a professional judgment and they don't think it's a good case? Now you get him to admit that his cronies did the right thing, and now you get him to say why you think they did the wrong thing now. So the defense kind of missed that opportunity, I think.
Decision that an arrest needed to be made.
And I understand, and I can tell you some of the investigative acts, but I cannot give you a complete list.
Got it.
Okay. We had an agent interview Larry English to establish that there was no theft at the residence.
Notice his body behavior, cocky, kind of twisting his shoulders when he's confident. Now he thinks he's going to stick it to the DA. In this guy's mind right now, oh, okay, you want to know the facts? I'm going to sink your boat. I'll tell you what the facts are. So he's going to give away everything that he thinks that is good that helps his case right now. He's not going to give away anything that hurts his case, anything that's not good for his case.
We also...
Why was that important to you to establish there was no theft at the residence?
Because part of the letter that you referenced to George Barnhill, he was alluding to...
Once again, the defense attorney asked him for a list, and he interrupted him on the first thing. Defense attorneys, pay attention. If you ask him for a list, let him give you the list. Then go back item per item. Don't interrupt him in the middle of a list, because you'll never get a complete list. And if you come back later and try to say, when I asked you this, you didn't do it, and then the court reporter shows that you interrupted him twice when he tried to give a list, and you disrupted his train of thought, because that's going to be my answer if you try to get me on that.
The fact that it was a burglary in progress. There's no evidence of a burglary taking place. The fact that Mr. Arbery had been there numerous times before, nothing had been taken. The fact that they were reported as trespassing, not burglary. Again.
Okay, so let's get on this bias thing he's getting here. The guy's been there trespassing numerous times. Wasn't arrested, wasn't charged, but he did trespass numerous times. We got him on video. Now he's saying burglary. Let me tell you something with burglary, and the defense attorney brings this out, but this has been my case from the jump street. Burglary is normally defined in most states when you enter a building or structure that is not yours, okay? You enter with the intent to commit any felony or any theft. So if you enter with the intent to steal, it's burglary. That's why when somebody enters a store with no money and they shoplift, you charge burglary. Well, Rick, how do you prove they were going to steal? Because they didn't have any money to buy anything. And if they can't buy something and they went into the store and they stole something, they entered with the intent to steal, because they damn sure didn't enter with the intent to buy something. So it's inferred that they entered with the intent to steal. Now, defense attorneys will tell you, well, how do you know he just didn't go in to look around and he wasn't planning on stealing and he wasn't planning on buying anything? He just wanted to look. How do you know it wasn't hot outside and he just went in to cool off, officer? How can you jump to the conclusion that he went in with the intent to steal? Well, because I have two brain cells and you obviously don't. But you're going to get here where this cop makes the conclusion that Arbery entered and he did not have the intent. If you can't go that he did have the intent, how are you going to go he did not? That's where this officer kind of steps on his pee-pee in my book.
And we had reviewed all Glenn County Police Department's case file. We then...
At that time, you had reviewed the Glenn County case file?
Interrupted him again.
In that 32-hour period?
Yes, sir.
Okay. That means all of their written reports?
Yes, sir.
The medical examiner's report?
Yes, sir.
Photographs taken?
Yes, sir.
Didn't have cell phone records at that time?
There was cell phone download. That part we had problems getting into because of the format, and I don't really understand that. I am not a technically wise person, but the person that was assigned to look at those cell phone records had issues getting into them. We were able to have to get another copy from the Glenn County Police Department to further look into the cell phone records, is my understanding.
If I could go back, so you spoke with Larry English, who said to you, or one of your agents, I have not, in fact, had anything stolen from me at any point in time. Is that correct?
From that residence.
From the 226 element.
They can establish at that residence.
Okay. And I think you said that, therefore, there was no burglary that happened in your mind. Is that correct?
That's correct.
Is it?
That's wrong. If somebody enters on a trespass at night, just because you can't prove he took something does not mean he didn't have the intent. If you're going to prove his intent was not to steal, then prove what his intent was. You can't just say, well, it wasn't to steal, but I don't know what it was. Well, then how do you know it wasn't to steal? This is the trap. This is when they write laws like this. This is what we call a specific intent crime. You must prove the intent of the person for some crimes. Some crimes are general intent. You don't have to have specific intent. And I don't want to go into off the book right now, but there's specific intent. Burglary is specific intent to commit any felony or any theft. So if I kick your door in and I go, baby, get ready, I'm about to rape the shit out of you, we have burglary, okay? If I see a TV and I reach in and I grab that TV through the window, we have burglary. I entered, I broke the barrier, I grabbed the TV and tried to pull it, that's my theft, I have burglary. Just by reaching in a window and putting my hand on a TV. But Rick, maybe he was just trying to readjust it so he could see it better. Well, that's because you're an idiot, but okay, maybe he could have. If and buts and coconuts. Okay? But that's what he's going to get charged with, burglary.
Is it that you believe that an item has to actually be stolen for the burglary to be committed?
My understanding of the law is for burglary to be committed, you have to enter a structure with the intention of committing a felony or a theft.
So that's my understanding of the law. Right? He just said that. With the intent.
Neither a fact could I establish in this investigation Mr. Arbery had committed.
Neither fact I could do it. I couldn't prove that he committed a felony, wanted to commit a felony, or that he wanted to commit a theft. So I couldn't prove it, therefore it's not burglary. Well, what was his intent? If you couldn't prove that was his intent, what was his intent? Well, I couldn't prove that either. So you can't prove that he entered not to commit a felony or a crime. So therefore, you jump to the conclusion that it wasn't burglary, it was just trespassing. Would you agree that he entered private property that wasn't his? Yes. Would you agree he entered it without permission? Yes. Would you agree he entered it multiple times? Yes. Would you say it's possible that he stole something and it wasn't missed and nobody saw it? Would you say that's possible? If the guy says no, he's lying. Of course it's possible. He wasn't on videotape the entire time he walked around a place. He could have went in. He could have took something outside. He could have slipped something in his pocket. Without being able to prove he didn't take something and you jump in an conclusion he didn't have the intent to steal, is BS. And see, here's where, and I know all the cops who think they're going to outsmart me here are coming here. Well, Rick, if you can't prove it, then you don't have a crime, you don't have the element. Well, let me tell you this, Mr. Wise Person. According to the law, I don't have to prove a felony was committed. I just got to be able to believe a felony was committed to act. That's right, pesky citizens. I don't have to know a felony was committed. If I think a felony is committed, I can shoot and kill you, and it will be justified by government as a police officer that I had a reasonable belief that a felony was committed. If I think you shot somebody and you're running away, and I think you have a gun and it turns out to be a cell phone, and in fact you didn't shoot anybody, and I shoot you, I am covered by law because I believed a felony has committed. When these guys acted, and this is going to be a hard hurdle for them to get over, they were acting as if they thought a burglary had been committed. Now we have to prove, was it reasonable that they think it was committed? I think they're pretty close there. He trespassed multiple times. He wasn't from the area. He was running from the scene. He tried to fight. He tried to evade. He didn't stop. He didn't call 911. He didn't act like an innocent person. His actions were consciousness of guilt of flight. But Ricky was scared and they were white. Well, I don't think the law is yet that black people can just be scared of white people. Because I know they say white people can't be scared of black people or we're racist. But maybe the law, they slipped it in that black people can automatically be fearful of white people. All right, here we go.
Okay, but the burglary statute, to your knowledge, does not require an actual theft to be completed. It would be to enter simply
True.
with the intent to commit a theft.
But at no time did it appear he was interrupted and he didn't steal anything, so...
He didn't steal anything. Your Honor, he's stating facts, not evidence. How do we know he didn't steal anything? Please, officer, enlighten me with your crystal ball. How do you know? Are you telling me he was under 24-hour surveillance every time he entered that room? Are you telling me he didn't know where that camera was and that camera didn't have blind spots? Are you telling me you got satellite surveillance of that area that he never stole anything, then why the hell did you just testify that he never stole anything? Man, this cop's, he is so pushing his agenda, I hope they ring his ass out in front of a jury.
I do not think you could establish as a point of law that his intention was to steal something if he had been in the residence multiple times and never taken something.
Notice the head swinging and the body shift, kind of cocky, kind of like, I got you, I know what I'm talking about. You can't prove it, I'm right and you're wrong. Unprofessional in my book.
And then he left without taking anything. That was my reasoning.
He'll be briefed on this and he'll be told, don't do that in front of the jury.
Are you aware of all of the times that Mr. English called the police about a suspicious person in his residence?
I am aware that he has called the police in the past about a suspicious person in the residence, yes, sir.
Are you aware if there are videos that exist of those moments where he saw a suspicious person on his cameras?
Yes, sir.
Have you reviewed that video footage?
I have reviewed the video footage he has provided to us, yes, sir.
And when is the video footage from? What dates is it from?
I don't recall the dates.
Okay.
If you had your case file, you could refer to it and find the dates. Rick, why are you be quiet.
October 25th, 2019 sound familiar?
Could be, yes, sir.
November 18th, 2019?
Could be, yes, sir.
Could be. No commitment. Not sure. I don't know. Sure, I'm being cooperative. Sure, whatever you say, counselor. I mean, that's kind of what you have to do when they're giving you facts that you don't have. If you had your own facts, then you could be sure.
February 11th, 2019?
That one I do remember, yes, sir.
And then the video footage.
Oh, so you did remember. A few minutes ago, you said you don't remember. But now you do remember. Am I to get that correct?
You're saying you don't see anybody stealing anything, actually?
I don't see Mr. Arbery stealing anything. Like I said, there were children that took some scrap wood, but he did not consider.
Notice how he discounted that there was theft from the building, but it wasn't Mr. Arbery. Because Mr. Arbery wasn't seen, but they saw kids taking scraps. See, I don't even have a problem if Arbery goes in there and takes scraps. Because scraps are kind of pickings, and a lot of people take scraps. But you normally don't enter the building to take scraps. Most things inside is for building. Scraps are usually outside on a corner. I've taken scraps of 2x4. Ooh, Rick, you committed a crime. They're going to come after you. Whatever. I mean, look, when they have a scrap pile that they're waiting for the dump to pick up, it's free pickings. So, and that's just reasonable. Kind of like when you put your trash on a curb. I can go dig through your trash and take, if you got a half-eaten donut and I want the other half, I can go take it out of your trash can and it's not theft.
When did that happen?
I don't remember the date on that.
But not the dates I've just disclosed.
I don't believe so, no, sir.
And
And my understanding is he knew the children and did not really consider that. I don't believe he called the police on that instance.
Oh, so he called the police on the other guy that he didn't know who was going in there who was an adult multiple times. You didn't find that suspicious, but he didn't call the cops when the kids were taking scraps. And you're connecting that as they committed a crime, but Mr. Arbery didn't. Really?
the 911 calls from those incidents, have you reviewed those 911 calls by Mr. English to see whether the statement he gave you about no theft matched what he told the police?
I have reviewed the report from February 11th, which reviewed that. But the 911 call, I do not believe I had personally reviewed it. No, sir.
To make a determination if he was reporting to police contemporaneously that he had, in fact, that thing stolen.
Judge, object to relevance. All of these questions are involving other acts, and we're here for probable cause as to the issuance of the arrest warrant for February 23rd of 2020. I don't believe we've had any questions about that today.
May I respond?
Yes.
The issue that I believe we heard on direct testimony was that there was a history of problems in the neighborhood that neighbors were communicating about, that Travis McMichael and his father believed that, I think the testimony was, the guy was running past the house. And so I'm merely inquiring if he is aware of the statements that the homeowner who owns the residence that was being burglarized, if he has reviewed that enough to determine.
Notice he used the term burglarized. That's good. Defense attorneys will always use the thing that helps their client. So he's saying the house was burglarized. He wants people to believe that. Be honest, I think the guy committed trespassing. We can't prove burglary. But I also think that he entered with the intent to steal, and he saw the camera, and he was searching things out on what he wanted. Now, could he have entered on some, he was just checking out the paint scheme? I mean, okay, he went out for a jog, 2 miles, 12 miles from his own house, staying with his mom, whatever. It doesn't make sense that he was checking out paint schemes versus scouting out the place. And I don't care if anybody went there. Now, if he was a neighbor and he lived across the street and he walked over there with his wife, now I think he's checking out paint schemes. Now I think they're checking out design. They're looking at the place. So Rick, if he brought his wife, then it's not burglary? No, it goes to reasonableness, you freaking idiots that want to come here and argue with the freaking wall. Reasonableness. See, they're trying to say, well, we had other couples walk through the house. Yeah, couples in the neighborhood, they check out houses. That's normal. We want to see how it's built. We want to see what it is. Oh, so a black man can't check out a house. Most people don't run to other neighborhoods and check out houses. If they do, they will drive their car and stop. They have nothing to hide. They won't run. They won't come back multiple times. They will check it out and be done. Goes back to reasonableness.
Whether that person's statements actually do establish a burglary or not.
I'll let you answer the question.
Thank you. So I guess my question was, it sounds like your answer is no. The 911 calls you have not reviewed. What Mr. English is telling the police contemporaneously on October 25th or November 18th about whether he believes something was stolen.
I have reviewed the February 11th report from the police where he clearly tells them that nothing has been taken, that the person is doing no damage.
On February 11th?
On February 11th, yes, sir.
I got you.
And in the past, he notes that in the report. So I have reviewed that police report, which is a statement that he made to a law enforcement officer prior to the...
Is it just me, or does everybody feel that this dog has this cop has a dog in the race? To me, this cop is so convinced that he's pushing his agenda that he's not non-biased. He's not being equal in answering the same way as he did the prosecution to defense. To me, it's glaring. Maybe to the rest of you, it's not, and you're going to say I'm just making it up, but to me, and I think to any seasoned cop, it's pretty glaring. He discounts facts that doesn't support his case. He's got confirmation bias. He makes points that helps his case in a cocky, arrogant way, like he's right and he knows what he's talking about, and the defense attorney's full of crap. Anyway, we're at 30 minutes. Here we go. I'll go to the next part. I don't know what part it is. I'll put it in the title. And just for the record, I stopped watching this right about here, so I don't know what's going to come. I had listened to this other part while I was walking, so I kind of had a little bit of a precursor of kind of what was going to happen. I don't know what's happening next, so it's going to be new to me and new to you. I thought, maybe I missed it, at one point, the officer was, the cop, or maybe it was when they were asking him about why didn't he bring the case file? And he was hemming along about the big case file and our procedure, and we got a download from Atlanta, and, you know, when he was going through all that. To me, this was a mispoint by the prosecution and the cop. Because had I been on a stand and I didn't want to bring my case file, it would have been very, and maybe I covered it. I don't even know if I covered it. I know I thought about it. It would have been very easy for him to say, hey, I have ongoing search warrants, and I don't want information revealed before I conceal it. I think I did cover that. If I didn't, I wanted to cover that because there's a reason for not giving away all your information before you do a search warrant. So if I didn't cover it, I kind of touched the here. If I did cover it, everybody be like, Rick, you're losing your mind. You already covered it. All right, here we go. End it for the next part.